Hello, my name is Anthony Foulier. I'm a barrister and I've been lecturing the company law course for the last 4 years. So I've taught the LLB classes and also the FE1. So in total, I've taught this course probably over 12 or 14 times. And what I wanted to do in this little introductory session is just give you a flavour of what the course is. Now, the first and most important thing is that this is a course completely directed at the exam. So what we do in each class is we go through problem questions and we make sure that we've done every single question that's ever come up on the exam. So the good news for you is that there's quite a lot of repetition in the company law FE1 exam. The examiner tends to choose topics that have been, the questions have certain similarities to previous years. So we will be seeing recurring, not only themes, that's obvious enough, but questions themselves. So what we hope to do is cover every single question so that on the day of the exam, you will already have done most of what you see before you. So that's the first thing to note. The next thing is that this is not a particularly long course. It's a course that sometimes has a reputation as being technical. Some elements can be dry and so on. Company law people don't feel the same affection that they do when they think about tort law or criminal law, ones that are automatically interesting. But I try to make it as interesting as I can, and it's not as dry or technical as maybe you've been led to believe. So just to give you an overview of the course, it's really broken down into a number of key areas, and what your course manual, which you'll get when you sign up for the course manual goes through the Act, the new Act, which, as many of you may know, came to force last June 2015. This is the Companies Act 2014, the biggest consolidation of company law in Ireland for over 50 years. So a lot of the law is pretty much the same. There are some additions, and those additions can be important. And where there are new elements, we obviously highlight that, and you'll know exactly where they are. But to give you an idea of how the course looks, so first of all, we've got incorporation and registration, the general background here to incorporating a company. There's not a huge amount of questions that come up on the exam on this topic. So sometimes you get essay questions that just talk about the advantages and disadvantages of incorporation. Very easy essay question. We then talk about corporate authority, corporate capacity, and the ultra vires doctrine, which has been done away with for private limited companies. It still exists for certain other types of companies. We have a look at that. We have a look at the capacity of directors to sign contracts on behalf of the board, and what is their capacity when they act alone. We look at separate legal personality, the most famous case, one of the founding cases of company law, Solomon and Solomon. We have a look at that, but not only that, the cases that follow on from it and what the exceptions are to this doctrine of the personality of the directors or shareholders being one individual personality and then the company being a separate one altogether. What are the consequences that flow from that? And when can the courts disregard that strict division? The next part of the course then talks about share capital. This is one that, again, gives rise to certain essay questions. The nature of a share sometimes comes up. Questions involving directors and dividends can arise, and we look at dividends in that part of the course. And then share transfer, which is a popular area of the course because it deals with directors refusing to register a transfer of shares. So we look at what reasons there might be for that refusal and when the directors can actually, when they can decide to refuse and when they can't. After that, then, we go into corporate governance. So far we've looked at part 2 of the Act, part 3, and now part 4, which is a meaty part, corporate governance. We look at not only meetings, the definitions of a member, AGMs, and protection for minorities. So the area that when a member or even a director is in some way aggrieved, perhaps the majority is acting in disregard of their interests or is oppressing them, we have a look at that area of the law. And that moves on then to part 5 of the Act, which is kind of taken in tandem with what we've just been talking about. That's directors. So that's a huge area. And what I always say is that there are 2 absolutely must-study areas for this exam. The first one is directors. You always get a question on that. And the second one is corporate borrowing. We'll talk about that in a moment. And what's so important there is that you have an exam with 5 questions on it, and 2 of them you know are going to be related to those 2 topics. So we cover absolutely everything to do with those questions and topics. And then you can kind of sit pretty and realize, right, well, 2 out of 5 are taken care of for sure. The next thing then we look at compliance and enforcement, a relatively small area, but the area of restriction of directors is very popular as an exam topic. One year it might be an essay, the next year it's a problem question, and then it flips again. So a very popular topic there. We look at disqualification in a little less detail because it comes up less often. A new thing called disqualification and restriction undertakings. We have a look at that. They haven't been examined yet because they're just brand new. And then reckless and fraudulent trading couple of interesting cases there, especially the fraudulent trading ones. After that then, corporate borrowing, so a very big area. We look at fixed and floating charges, what security is. We look at retention of title clauses and fixed charges on book debts. Those are the topics that are covered there. Really, really important. And as I say, we go through every one of them, make sure that you know them inside out. You have plenty of opportunities to ask questions. And then the final area of the course is the insolvency area. This is, in general, a very simple area. It's not often examined, but it's a very valuable one for you in terms of your future practice as well. We look at receivers, examiners, and then winding up. So those are three areas, and we also compare and contrast them. Once there was a question that asked candidates to do that. It's only come up once, but compare and contrast the receiver, liquidator, and examiner. So as we're doing those chapters, we're kind of thinking, can we compare and contrast them? That's a very good exercise, even if it never comes up in the exam. It's a very good exercise for you to be able to know that you thoroughly understand each area. And then the final chapter is on the realization of corporate assets, which is a fancy enough sounding title, but what we're talking about there is there's a moment when the liquidation commences, and what happens if assets belonging to the company are transferred out in a particular time period before the liquidation commences, or if they're transferred out after the liquidation commences. There are ways of unraveling those transactions, and that's a very popular exam topic as well with your examiner, and it's one that is very important to look at. So that frequently comes up, and we go into some detail. There are a few technical elements there with regard to the final chapter. That would be chapter 18. So in total there are 18 chapters, and really that's what I wanted to kind of convey to you in this short overview of the course. So I hope you'll sign up. Everybody who does it gets a lot out of it, and the results are very, very successful. So thanks for your time. Hope to see you in the future.